This courtroom hearing is a perfect example of how quickly patience can be tested when reality meets denial. From the very first minute, the judge is forced into a frustrating back and forth with a self-proclaimed sovereign citizen who refuses to answer even the simplest questions. Instead of addressing the charges in front of him, the defendant launches into long speeches about jurisdiction, injured parties, and imaginary legal loopholes he believes place him above the law. As the hearing continues, the judge calmly explains, again and again, that this is a criminal case, tied to a real location, and fully within the court's authority. But every explanation is met with another demand, another interruption, and another attempt to redefine the rules of the courtroom. The defendant insists the judge is merely a trustee, claims the court has no power over him, and repeatedly refuses to cooperate with basic legal procedures. What makes this situation even more unbelievable is what's at stake. This isn't a minor issue or a paperwork dispute. The defendant is facing serious felony charges, including firearm-related offenses that could result in real prison time. Yet instead of protecting himself legally, he chooses to stall, argue semantics, and push conspiracy-style arguments that have failed countless times before. Minute by minute, the tension builds. The judge gives clear options, reasonable explanations, and multiple chances to move the case forward. But when the defendant continues to talk in circles, the court finally steps in and takes control. In the end, reality wins, and the legal process moves forward, whether the defendant accepts it or not. This video is a powerful reminder that courtroom theatrics don't beat the law, and refusing to cooperate only makes the consequences more severe.
Area of the Frank Anthony Michaud Jr. Estate, making a special appearance, not general, and I appoint you as my trustee for the record.
And Mr. Michaud, were you able to hear Mr. Sullivan indicate that he is standing by as shadow counsel?
I heard him.
Okay. This case is scheduled this morning for PCC. How are we proceeding?
I'm here challenging the jurisdiction for the record, ma'am.
Judge, the people are prepared to set a preliminary exam in regards to this matter.
Mr. Michaud, you're able to raise that at the exam date, the allegations that these events occurred at Detroit Metro Airport, which is located in the city of Romulus. Are you ready to have the exam scheduled, sir?
I'm not here to
Mr.
have
Michaud?
an exam. Still trying to wonder why we moving forward with even having an exam, especially after not having, by the due process, even having a probable cause hearing.
It's not a problem. It's probable cause conference, sir, at which time the parties will indicate if they're ready to proceed to exam, if there's a plea or a waiver or some other resolution. So at this time, the assisting prosecuting attorney has requested that an exam be set. Are you prepared to have the exam scheduled?
No, as me here challenging the jurisdiction for the record, I want to put on the record that once the jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That's Mello versus U.S. for the record.
And sir, what is it that you find, what is your allegation regarding the jurisdiction?
Well, what is the jurisdiction that the court is operating up under, ma'am? The Sixth Amendment has—
The court has already—
the right
Mr. Michaud, the court has already indicated that the allegation is that this event occurred at Detroit Metro Airport, which is located in the city of Romulus.
Are
you indicating that this event that brings us here to court did not occur in the city of Romulus?
Well, I would like to know what jurisdiction is this court operating up under, so that I can properly defend myself and represent myself for the record. So the Sixth Amendment grant me the right to know the nature and causes of these actions. So I would like to know what jurisdiction.
What the file indicates is that there's an offense dated February 23rd, 2021. And again, that the case happened at Detroit Metro Airport, which is located in the city of Romulus. That is a jurisdiction within this court's parameters. So that being the case, would you like to have an exam scheduled?
No, I would like to have, under what jurisdiction are you proceeding with, so I can properly defend myself?
I've said it three times already, Mr. Michaud. If you have indications or information that the event as alleged did not occur in the city of Romulus, I'll hear it at the exam date.
That's not a jurisdiction. The jurisdiction has to either be one or two. Is this common law or admiralty jurisdiction, or is, for the record, you gave me a location,
Mr. Michaud,
a jurisdiction.
Mr. Michaud, respectfully, what we'll do this morning is either schedule an exam, adjourn the PCC, or waive the exam. One of those three things.
Well, the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. That's Higgins versus Levine. So I still would like to know under what jurisdiction, so that I can properly defend myself, not the location. I need to know what jurisdiction is this court operating up under.
Mr. Michaud,
it wouldn't be a violation of your oath of office to tell me.
Mr. Michaud, for probable cause conference, and I'm sure that you've heard this before, we're doing one of a few things. We are scheduling the exam, we're adjourning the PCC, or we're waiving the exam. How are we proceeding?
We can't proceed until jurisdiction is proven on a record, so that I can fully have an understanding of what's going on. I still don't understand what is going on without jurisdiction being proven on the record.
What don't you understand, sir?
I don't understand what jurisdiction are you operating up under. I have the right to know. And are you denying me my right to know what jurisdiction are you operating up under? Because it is your constitutional oath to let me know what jurisdiction it is that you are operating up under. And you still have not yet.
This is the 34th District Court, Mr. Michaud.
That's not a jurisdiction. That's not a constitutional jurisdiction, ma'am. Is this common law or admiralty? Is this criminal or civil?
It's a criminal case, sir.
Okay, if
it's a criminal case where it's alleged that you were a felon in possession of a firearm and that you carried a concealed weapon, that's count 2, and then count 3, felony firearm. Those are the allegations. I've given you the 3 counts in this matter. I've given you the date of the offense, and I've given you the location of the offense. We can do one of 3 things this morning, sir. We can adjourn the PCC, we can schedule the exam, or you may waive the exam. Which would you like to do this morning?
I want to have my rights given to me, and my right is to have the jurisdiction of the court.
I've already indicated to you, sir, what the court is.
Is this common law or admiralty? That's the only jurisdictions that we can, that I know of. You still haven't acknowledged neither one, and I still don't understand what's going on. Until you acknowledge one or the other, we still haven't got jurisdiction on the record.
Mr. Michaud, do you intend to represent yourself in this matter going forward?
I would like to know jurisdiction so I can properly proceed to present myself properly. I can't properly present myself or defend myself without knowing what jurisdiction that you're operating up under. And you said it was criminal, so if it's criminal, and for a crime to exist, there must be an injured party, a corpus delicti. There can be no sanction imposed or penalty imposed on one because of this constitutional right. So if this is a criminal, where is the injured party? Who have I injured? I have the right to face my accuser, face the one who is bringing these allegations against me, ma'am.
Mr. Michaud, if you wish to be able to defend yourself and hear witnesses against you, the court is happy to schedule the exam. Is that what you're asking this morning?
No, as I appointed you as my trustee, I demand that you dismiss these actions for no corpus delicti, no proper jurisdiction, for no proper crime, injured party.
Mr. Muhammad, your response to Mr. Michaud's request that this case be dismissed.
Judge, the people's position is we would object to dismissing this case on the basis of lack of jurisdiction. As you mentioned earlier, this crime did occur in the county of Wayne, and thus we do have jurisdiction.
There is no jurisdiction without the injured party, for the record. So I would like to face the injured party for the record.
And Judge, my response is, then we should
Yes, sir.
Then I believe we should set this for a preliminary exam.
I object to that, ma'am. You cannot proceed without jurisdiction being provided on the record. And you being my trustee, for the record, ma'am, you have to dismiss this case as I demand, for the record.
Your request to have this matter dismissed is denied. Mr. Michaud, my question will remain the same. Would you wish the court to schedule an exam? Do you wish to waive that exam and have your case bound over to Third Circuit Court, Frank Murphy Hall of Justice? Or do you wish to adjourn the PCC? Those are your options this morning, sir. They're going to stay the same.
I would like for jurisdiction to be provided for the record, and that if not, I demand dismissal, for the record.
This case will not be dismissed, sir. Would you like the exam scheduled? Would you like to waive the exam, or would you like to adjourn the PCC?
Again, jurisdiction for the record. You cannot proceed without, when once jurisdiction is challenged, again, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That is Mello versus.
Mr. Michaud, this is the last time that I will say this. I've indicated to you that this court is the 34th District Court, that this case is criminal in nature, and the allegations that it occurred at Detroit Metro Airport, which is located in the city of Romulus. If there's something you wish to present, you may do so at the exam. You may present your motions at the exam date. So do you want an exam? Would you like the case to be waived, or would you like to adjourn the PCC to confer with Mr. Sullivan?
No, I would like for this case to just be dismissed because the lack of providing a proper jurisdiction would make it seem like there is some secret jurisdiction being held against me without me knowing, and I don't consent to any jurisdiction that you have presented. I reserve all my rights, for the record.
Understood. And that being the case, Mr. Sullivan, is there anything you'd like to add, sir?
Judge, I don't know what to say. I'm not sure that I still have authority to represent Mr. Michaud. I will say that Mr. Michaud has made his arguments, a couple times, and I think that the arguments have been, or the motions have been denied. And I've explained to him that those motions, his arguments, are preserved on the record, and that he maintains the ability to appeal any denial of his motion to dismiss. He would be able to appeal that first at the circuit court level and then up to the Court of Appeals. So I've done my best to advise him of his rights to continue making that argument. I will also, I think the court may already be aware that Mr. Michaud is not in custody on this case. He's in custody on a contempt of court that Judge Oakley sentenced him to back at the end of January. So I don't know that there is, unlike clients that are in custody, a reason to expedite the setting of the preliminary exam. So I really, I want to defer to Mr. Michaud's stated interest, what it is that he wants to do with this case. I've given him advice, and I don't know what I can do beyond that. Again, I don't want to create any conflict in my representation.
And Mr. Sullivan, the court wasn't asking you to. The court has heard Mr. Michaud's arguments. The record has been made. Your statements have been preserved, Mr. Michaud. And at this time, the court can do one of two things. We can schedule you for an exam next week. We have space available next Wednesday, the 28th. We can adjourn this matter for another PCC next Wednesday morning at 8:30, or you may waive your exam. Your response is one of those three things, please, sir.
Well, my response, I want to ask you a question. Are you honoring your oath to the Constitution today?
Yes, sir.
Okay, and I accept your oath, and upon you honor your oath.
Then Mr. Michaud, no. I've answered your question. I've now given you your options multiple times. The court has other cases. Are we scheduling an exam for next Wednesday? Are you waiving your right to have the exam? Or would you like another PCC next Wednesday morning at 8:30 so you have time to consider your options and how you will proceed in this case?
I demand a dismissal.
Hi, sir. The record's preserved. If you wish to appeal that decision, you may do so in writing properly filed. Again, exam, waiver, or adjourn PCC.
Dismissal for the record. I demand that you dismiss this you cannot move once jurisdiction is challenged, the court cannot proceed for the record, ma'am.
And Judge, for the record, the people would like to request a preliminary exam. There will be no plea offer. We did already have a probable cause conference in this case, so we are prepared to move forward, Judge, just for the record.
Marianne, is there space next Wednesday afternoon?
Yes, Judge, at 2:30.
I object. Court cannot proceed without jurisdiction for the record. Jurisdiction has not been provided for the record so that I may.
Mr. Michaud, the court has responded and provided the appropriate information to you. The exam will be scheduled for next Wednesday, February 28, 2024, at 2:30 p.m. in person here in courtroom number 1. If there is a motion that you want the court to consider, the court will take it up as a preliminary part of the exam.
I object.
Anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Michaud?
I demand for dismissal for the record. Court cannot proceed without jurisdiction being provided for the record, and yet you still continue.
Your oral motion having been heard and denied. Anything else?
Why are you denying to put the jurisdiction on the record? Why? I just want to know why. Why are you denying?
I've done that, Mr. Michaud. I've done that. I've asked you multiple times how you would like to proceed with this conference. You refuse to answer the court's question regarding how we're proceeding. The prosecution has requested an exam. The court has scheduled an exam. If there are things that you wish to take up preliminary next Wednesday, we will take it up before the exam starts.
I'm not prepared. Do not wish to have a preliminary without me knowing how to defend myself under which jurisdiction. So it's still a violation of my rights, my due process. You're moving forward without telling me which jurisdiction so that I can properly defend myself and represent. Civil and criminal procedures have different jurisdictions, and I need to know which one are you operating up under now. How could you?
You do, Mr. Michaud. The court's answered the question multiple times, and the court deems this matter concluded. I will see you next Wednesday afternoon.
From the very first moment, the tension in this courtroom is impossible to ignore. A self-proclaimed sovereign citizen stands before the judge, refusing to acknowledge the authority of the court. Instead of addressing the charges in front of him, he launches into endless arguments about jurisdiction, claiming the court has no right to hear his case because, in his view, there's no injured party and the judge is only his trustee. He speaks with confidence, convinced that he has found loopholes that will allow him to escape accountability. The judge listens calmly, but it's immediately clear that this will test the limits of patience. She explains, over and over, that this is a criminal case with real consequences, tied to a real location within the city, and fully under the court's jurisdiction. Every attempt to sidestep the issue, to redefine the rules, is met with clear instructions to follow the law. But the defendant refuses to cooperate. He demands impossible answers, challenges the court's authority, and spins long-winded arguments that go nowhere. Minute after minute, the pattern repeats. He insists on knowing what type of jurisdiction the court is exercising, common law, admiralty, or something else he has read about online. He refuses to accept the judge's explanation that the case is location-based and criminal in nature. Every attempt to move forward is met with resistance. He interrupts, he stalls, he repeats the same points in slightly different ways, hoping that if he delays long enough, the case will be dismissed or forgotten. What makes this encounter truly extraordinary is what's at stake. These are not minor charges or civil disputes. The defendant is facing serious felony offenses, including possession of a firearm and carrying a concealed weapon. Real prison time is on the line, yet he continues to argue legal theory instead of addressing the facts or cooperating with the court process. It's almost impossible not to feel the frustration building in the courtroom as the minutes drag on. The judge gives repeated, clear options: schedule the preliminary exam, waive it, or adjourn the conference. But each option is met with more questions, more interruptions, more refusal. The courtroom transforms into a battle between logic and defiance. The longer this goes on, the more the defendant seems to be fighting the system out of principle, or perhaps just out of sheer stubbornness, testing how far he can push before real consequences catch up with him. Despite the delays, the judge maintains control. Her patience never breaks, even as the defendant continues to ignore instructions and questions. Each explanation is given slowly and deliberately, ensuring there is no confusion about what the court expects. But the defendant has his own agenda, a mix of conspiracy theories and pseudo-legal reasoning that seems designed to frustrate everyone in the room. Every time the judge clarifies, he finds a new angle to argue, a new reason to resist, as if playing a game where the rules only exist in his mind. The hearing stretches on, and viewer can sense the growing tension. This is not just a courtroom battle, it's a study in human behavior, ego, and denial. It shows how a single individual can challenge the law simply by refusing to acknowledge it, how patience can be tested to its limits, and how stubbornness can create chaos when mixed with legal ignorance. It is both frustrating and captivating, and it's easy to understand why anyone watching would feel the same mix of disbelief and irritation. As the minutes pass, the stakes remain. This is a criminal case with real consequences. The defendant is not arguing a civil matter or a minor dispute, he is facing felony charges that could change his life. And yet, instead of focusing on his defense, he chooses argument over cooperation, theory over reality. It's almost as if he believes the courtroom is a stage and the law is merely an obstacle to be outwitted. But the judge refuses to play along. She continues to assert the authority of the court, explains the legal procedures, and gives him every chance to make a rational decision. The tension is palpable. Every word he utters, every challenge he issues, is met with calm, methodical responses from the judge. The back and forth stretches on, a clash of stubbornness against reason, of pseudo-legal arguments against real-world consequences. And yet, through all of this, the court moves forward. Every attempt to derail the process only reinforces the need for order, clarity, and legal compliance. The system is unshaken by theatrics or defiance. Finally, after countless interruptions, repeated challenges, and endless questioning about jurisdiction, the judge takes control and sets the preliminary exam. The process moves forward, despite every effort to stall. The defendant leaves without victory, and the charges remain, waiting for resolution through established legal procedures. This moment drives home a powerful lesson. No amount of argument, delay, or refusal to cooperate can defeat the law. Reality cannot be negotiated away. Watching this unfold is both fascinating and exasperating. It's a study in human psychology as much as it is a legal proceeding. The combination of stubbornness, pseudo-legal arguments, and deliberate stalling creates an almost surreal atmosphere in the courtroom. Yet it is also a testament to patience, authority, and the careful application of the law. The judge demonstrates that, no matter how chaotic a defendant may act, order and justice can still prevail. By the end, the message is clear: courtroom theatrics do not override legal responsibility. Personal beliefs, no matter how strongly held, do not exempt someone from facing the consequences of their actions. And while watching a sovereign citizen challenge the law may be frustrating, it is also a reminder of the strength of the judicial system and the importance of following established legal procedures. This hearing, from start to finish, is a vivid example of what happens when stubbornness meets structure, when theory meets reality, and when patience meets defiance. It is both maddening and educational, a story that captivates viewer while delivering a clear, undeniable message: the law does not bend to belief, argument, or delay. The consequences remain, the process moves forward, and the truth is inescapable.